So we are right at 12 o'clock on the dot, so we can go ahead and get started. So I will go ahead and turn it over to Megan Schmidt from ODHS. If you guys have any questions throughout the presentation, go ahead and feel free to drop them in the chat, and I'll monitor that. I can make sure that those get brought up to Megan. So Megan, I'll turn it over to you. Thank you.
All right. Hello. Megan Schmidt, she, her pronouns. I'm a permanent C supervisor at Marion County Child Welfare. My unit specializes in perm guardianships and adoptions. So I was asked to talk about those today, and give me just a moment to figure out how to share my screen and get that going. So let's have a little PowerPoint here. Okay. Okay, can you guys see that?
Yes.
Yeah.
Okay, great. All right, so just so you know, I can't see you. So if you have your hand raised, Dennis will have to interrupt me, or just feel free to interrupt me. So okay, so first I'm going to talk about guardianships. There are two types of guardianships that we do, durable and permanent. So first I'll talk about what they have in common, and then I'll talk about what the differences are, because the differences are pretty significant. So in both a durable and a permanent guardianship, the child remains a ward of the court. The guardian has to write a yearly update letter to the court, essentially saying how things are going. The parent can ask for a court hearing to discuss concerns or requests. So the way that happens is they contact the court, and the court can say yes or no, we're going to let you have a hearing. And then, just so you're aware, something we tell guardians is that the parent likely will have an attorney at that hearing, but the guardian potentially would have to hire their own attorney. Unless they qualify for a free attorney. So that's something for them to keep in mind. That's something we look at is, are we setting up hearing guardianships with parents who are likely to pull guardians into court all the time, or is that unlikely? So it's one of the factors we look at. We do guardianship assistance and mediation for both types, and that mediation can be with not only the biological parents, but siblings and extended family. So in order to qualify for that guardianship assistance, it's the same for both types. The child has to be placed in a fully certified home for 6 months if it's a relative, or 12 months if it's in a non-relative home. And that often can be confusing, because sometimes we'll place with a relative under what we call an emergency certification, and their full certificate for that, when that timeline starts, isn't till potentially 6 months later. So it doesn't necessarily count from the date that that child is placed. It's from when that full certificate is issued. And so that's when we can apply for guardianship assistance. So sometimes we will know we want to move forward with a guardianship, but we can't until we've hit that timeline, and we can move with that assistance. Okay, if the current provider is not a relative, this is really important because it comes up all the time. They can't be designated as a guardian unless all interested relatives are ruled out. So that means that if you have a kiddo who's been in that home for years and you have an out-of-state relative who wants to be considered as a guardian, we have to look at that relative before we can consider the current provider. There's no like current caretaker. For those of you guys who've been around, we'll talk about that under adoption. There's no current caretaker law under guardianships. So if you are proposing a guardianship or supporting a guardianship with the hope that the current provider who's not a relative would be the guardian, that's something to take a look at. The way that we get permission internally to seek a guardianship and to designate a guardian is through something called a permanency committee. And that is something you guys would be invited to be able to share your opinion, not only on the plan, but on the proposed guardian. In guardianships, siblings can be placed with separate guardians, and they're with contact with some kind of plan for contact. I mean, we don't have to go to a committee to get permission for that. That's as long as we're designating each guardian. Does anyone have any questions about any of that? Let me be able to see you. There's a lot of information. I think, Craig, you have your hand up? Oh, okay, your box is, okay. No questions? All right. So we'll talk about how the two forms of guardianship are different then. So in a durable guardianship, any party can petition the court to have the guardianship set aside. So that includes the biological parents. So they can petition the court saying they're safe and they're ready to parent and they think it's in the best interest of that child. In a permanent guardianship, only the guardian and the child after age 14 can petition the court to have it set aside. So that's a significant difference. In a perm guardianship, there's a petition that we have to prove. So like similar when we talk about the termination, we'll file a separate petition. We have to serve them and we'll have a trial potentially on that petition that alleges why that child should never be parented by that parent again. Versus in a durable guardianship, there's no new petition. We just have to prove it's in the best interest not to go home. And we rely on the initial jurisdictional basis. So whatever we got in the beginning, that's what we're relying on, which becomes pretty important because if that parent at any point can prove that that original jurisdictional basis is no longer accurate, they can have that guardianship overturned. Now, that may not be an issue, right? Because we may be hoping for that kiddo to be able to go home at some point, but the parent just isn't ready. Or it may feel like a pretty significant issue depending on the case. Now, legally, this is potentially possible for a permanent guardianship as well under the statute that guardianship is under, but nobody's tried it yet. So until something happens, it's always kind of like this ambiguous possibility. And then in order to go for a permanent guardianship, the child welfare has to stop with their attorney because we have to make sure we have the necessary proof because of that separate petition. And it's the same level of proof for a termination of parental rights in terms of fitness of parent. There's some other findings under adoption that you don't need for a guardianship, but that level of proof saying that parent is not able to parent is the same. Anyone have questions about guardianships? There's a lot of information.
I do.
Yes, go
Megan? Who actually determines durable versus permanent guardianship in the first place?
So that's something that usually the agency will decide and but also asking the team, right? So like we would reach out to you guys and discuss a plan. When we're talking about guardianship, we should be asking you guys about whether you would support a durable or permanent guardianship, but also is somewhat determined by the level of evidence we have. Like if our attorney feels like we could not prevail at a permanent guardianship trial, then likely we're going to be looking at a durable. So it's kind of a combination, but we should be asking the child's attorney, CASA, whoever the proposed guardian is as well, because they may feel comfortable with one over the other. And ultimately they're the person who's going to have to live with whatever plan we end up with. Does that answer your question, Doug?
Yeah, thank you.
Okay.
Barb,
I think you had a question.
I have a question. What about when I'm quite sure it's a durable guardianship, but after like 3 years or so, and one parent has gotten out of jail, reformed, or trying to reform and wants to get custody back. How does that work? And what's the responsibility of the current guardians as well as the parent? And how does that process work?
So that parent would do one or two things, right? They would either petition the court to set aside the guardianship and the court would set a hearing potentially if they granted their request for a hearing. And people would present evidence as to why they think this is in the best interest. And maybe everybody's in agreement, right? Because maybe grandma was guardian and now dad's out of prison and he's ready to parent and everybody wants it to dissolve. And so it's not really contested. And some cases it is contested, right? The guardian's like, no, I do not think it's safe for this child to go home to this parent. And then they would have to present evidence in front of the judge. Or if it's a durable guardianship, that parent could also contact their attorney and say that this jurisdictional basis is no longer valid. So maybe we only got jurisdiction on that parent being incarcerated. Well, that would no longer be valid. And likely it could just be dissolved based on proving that that jurisdictional basis is no longer true. Now, if we have jurisdiction on multiple things like substance abuse or domestic violence, that those things may still be an issue. And so they would have to have evidence to prove to the court that they're no longer a valid issue. No longer
Would they have to get their own lawyer, or would it be also all through DHS? And what about the other side for the guardians who, in this case, I think it's highly unlikely that they would get custody, but how does that all work as far as the representation?
So we're not involved in those guardianships unless the court pulls us in. So essentially, like the parent, yes, they would have to apply for a court-appointed attorney if they still qualified for one financially, and the same thing for the guardian. So either they could say, we don't make enough money, we need a court-appointed attorney, or they would have to hire their own attorney for that hearing or go in without representation.
Okay, thank you.
Yeah.
Megan, quick question. What visitation rights do the parents have for the two different types of guardianships?
So the mediation process is still the same, and whatever mediated agreement they come up with, it becomes part of the guardianship judgment. So usually that mediation has some kind of caveats like, if the parent doesn't follow through with that mediation, then it's null and void and stuff like that. But the parent can also petition the court to ask for a hearing to discuss things like visitation. Let's say they made an agreement on visitation and they feel like the guardian is not fulfilling their end of the mediation, or they feel like their circumstances have changed and they want more visitation. They could ask the court for a hearing and the judge could grant it and discuss the issue of visitation.
Okay, thank you.
Yeah. Any other questions about guardianship?
I have one.
Yeah.
Well, first, are the guardians provided any kind of benefit for being guardians, like financial reimbursement or medical coverage for the child or that sort of thing?
Yes, they can get guardianship assistance. So usually it is less than the rate that they're getting as just resource parents, but they can qualify for guardianship assistance. And as part of that, they can continue to get the Oregon Health Plan.
And oh, I'm sorry.
Oh, no, I was going to say, if we're placing out of state, the insurance piece gets a little trickier just because we have to make sure they qualify for their local Medicaid. But yes, they can still qualify for the health insurance.
And the other question was the child, by going to guardianship, they do not lose any of their potential benefits of having been in the childcare system, such as educational assistance or housing assistance when they get older. Is that the case?
So what benefits they qualify for in terms of those, like, I think you're talking about like through the ILP services or educational credits, depends on how old they are when we finalize the guardianship. So certain things they can still get depending on what age they are. There is some housing subsidy that they will not get. You can only get that if you have an open child welfare case. So that is something that they will lose. I mean, I think that the question is, there is a benefit of having a permanent family versus like bouncing around in care. So really looking at the age and the needs of that child to determine which of their needs is going to be greater, right? If you're talking about a 17-year-old who is really interested in living independently, we may make a different decision than like a 4-year-old, right? Because those educational benefits are going to be a long ways. And this assumption is that that guardian is going to make sure that they're assisting as they can for their own child.
Thank you.
Yeah. Okay. And also, I'm just putting it out there just because there's so much unknowns in the world. All of those benefits we were talking about through the educational process, they're all federally funded. So if that ever goes away, I don't know what that's going to look like. Just putting that out there in the world. All right. Any other guardianship questions? That went faster than I thought. So I got lots of time for questions if you guys have them. No? Okay. All right. Let me pull up my slide on adoptions. Okay. Adoptions, how are they different than guardianship? So some of these are going to seem obvious. Some of these are a little nuanced, but the adoptive parent is legally the child's parent, unlike so that child's no longer a ward of the court. That child and the adoptive parent can move out of state or country without permission. In a guardianship, they have to ask permission to leave, or they have to at least notify the court. They don't have to provide updates to the court. They can go about their lives with no obligation to the juvenile court at all. The biological parent does not have the ability to request a hearing to discuss things like medical decisions or visitation like they do for a guardianship. The adoptive parent cannot ask to dissolve the adoption. So unlike a guardianship, that guardian can be the person who says, I don't think this guardianship should continue. I want to dissolve it. They don't have the ability to do that. If that adopted child comes back into care, it's because they have voluntarily or involuntarily, if we've removed that child, placed that child back in care, but they will remain their parents. So they'll be legally responsible for that child. So some folks, that is a huge consideration because they're the needs of that child and they have fears about what that will look like in the future. And some folks, that is not an issue. If we are seeking to place siblings in separate adoptive homes, we have to go to what's called a sibling planning committee and get permission, because we are essentially going to make those siblings not siblings anymore, right? Because we're having them adopted by two sets of people. Now, obviously, biologically, they'll still be siblings, and we will offer sibling mediation, but because we're legally separating them as legal siblings, it requires a sibling planning committee. You would be invited to that committee to share your thoughts. And there has to be a pretty compelling reason why we would do that, not just that kids have been placed separately, but there's a reason why these kids can't be placed together for adoption. In adoption, unlike guardianship, we can study multiple people and then go to adoption committee to select them. So you can have multiple relatives you're looking at, or we'll talk about some other ways that folks that we might be looking at for an adoption. Unlike guardianship, we can do international adoptions with relatives. So if you have grandma who lives in Mexico, we could study her through their child welfare organization and place the child in Mexico for adoption only. We talked about that petition in a PERM guardianship. So the difference between a PERM guardianship petition and a termination of parental rights petition is that we have to prove it's in the best interest of the child to have their parents' parental rights terminated, versus just that parent should never parent that child anymore. So that has to be specific for each particular child. So let me know if you have questions on that. But and then unlike guardianships, there are rules that if you have a current non-relative placement that the child's been in, and they meet criteria for what we call a current caretaker. So that child has been placed in that home for over a year or half their life. If they're under the age of 2, they can be considered in an adoption committee just like a relative. So that allows us to look at them as well as the relatives versus that guardianship. Like I said, we have to rule out all relatives before we could consider who the child is currently placed with if they're a non-relative.
Megan, quick question.
Yes.
You mentioned the sibling planning committee or whatever that
Yes.
was.
Yeah.
Do you go through that at all with guardianships or not?
Nope. For some reason, at this point in time, that's not a requirement. We could designate multiple placements for different siblings for guardianships.
Okay, thank you.
Yeah. It's an adoption specific rule in our policies,
Okay.
just like the current caretaker. Yeah. All right. That could change. Obviously, any of this can change at any point, right? Because we update our rules, new laws could pass, things like that. So, okay. So how, unlike, so in the guardianship, we go to PERM committee to get permission. The way that we seek permission to change the plan to adoption is at something called a legal assistance specialist staffing. It's an internal meeting with the worker, attorney, and what we call the LAS. So that's the legal assistance specialist from central office to get approval to seek a plan of adoption. And this is not something you'll be invited to because it's a conversation with our attorney. It's considered attorney-client confidential conversation. So we could tell you what the result of that is, but you wouldn't be invited to this meeting. And so what we're looking for there is looking at the legal sufficiency to terminate parental rights and determine if we can achieve an adoption for that child or sibling group. The reason we want both is we do not want to create legal orphans. If we think there's lots of times when we think we have the legal sufficiency to terminate parental rights, but we're not sure we have an adoptive resource, we may hold off on approving that because again, we don't want to create legal orphans that grow up in our system with no parents. And the reason why our central office is involved is because once they approve a case for termination, they pay the bill for that termination of parental rights, and they do not want to pay for it if they don't have a say in what they think is legally sufficient. All right, there are three main components of achieving an adoption. So legally freeing a child, and we'll go through each of these, selecting a placement, and then finalization. So the legally freeing and selecting a placement ideally would be happening at the same time. They're two separate processes, but they can happen simultaneously. And then the finalization paperwork can't happen until both of the other two are completed. So legally freeing a child can be done in multiple ways. Relinquishment, so a parent's voluntarily saying, I give permission for the agency to agree to an adoption, consent to an adoption. I'm relinquishing my rights. A stipulation to the termination of parental rights petition is basically saying, we filed that petition. They're saying all of this is true. I agree that the agency can prove that this petition is true. And so essentially I'm waiving my right to a trial. It's kind of like when folks make an admission in a criminal case, right? They plead guilty instead of taking it to trial. We can do a termination at that termination of parental rights trial, and then we can do a trial without parent. So a trial without parent is essentially we've legally served that parent for the hearing, and then they don't show up, and we present evidence without them present. And then a probate guardianship, which is essentially this child comes in as a legal orphan because all of their parents are deceased. And so this just basically is us asking the court for permission to consent to their adoption because there's no legal guardian to relinquish their rights. Those are thankfully less common, but it does come up occasionally. Okay, selecting a placement. If there's only one potential adoptive resource and they are a relative or a current caretaker, so again, that current caretaker is the person who currently has them, who's the child's been placed with for a year or half their life if they're under the age of 2. We complete an adoption home study through our certification, and then we select through what we call a caseworker selection process. So, and unless the child is the relative's out of country. And you would be invited to that caseworker selection. So usually that's me, my worker, and then you or the child's attorney. If they choose to attend, you would have had time to review that home study. Likely you would know that person already because you're involved in the case and you kind of know who we're looking at. And then you would get to share what any concerns you have, whether you think they should be the adoptive resource, and any pros that you think, and reasons why you think it's a good match. If there are multiple relatives or a relative and a current caretaker, then it goes to an adoption committee. You would be invited to that adoption committee, again, to share what you know about the kiddo, about you would have access to the home studies. You would get to hear presentations on whatever families are being considered, and ask questions, and then again, present who you think should be selected and what strengths or concerns you have about each home. If we have no one, right? Let's say this child does not have any relatives, the current provider do not want to be considered for adoption, then we'll do a search for an adoptive home through a process called recruitment. And then we would select families and then go through that adoption committee. Again, you would have access to not every home study we get, but any home study that we are putting forward to the adoption committee to select from. So sometimes we only get a few home studies. Sometimes we get 50 home studies. It really depends on the particular child that we're recruiting for and how broad our search is. We can recruit in just Oregon, we can recruit in the Northwest, or we can recruit across the United States. We don't recruit internationally, though.
Question.
Yeah.
How do you recruit for adoptive parents? I mean, like, do you put an ad in the paper or?
Not quite. We do create what we call a bulletin. So a write-up about that child, their needs, what they want, what we think that would be important in an adoptive home. And we get pictures of them, and they are posted on a website, but you need an approved adoption home study to get a password for that website. So families who have approved adoption home studies through our agency and private agencies have access to that. And so they would have their adoption worker send us their home study saying they're interested in being considered as an adoptive resource. Same thing for the Northwest. The nationwide, actually, I don't know if you need a home study. That one is a little more broad, so we're pretty careful about which kids we put on there. We also can do something called child-specific home study through the Boys and Girls Aid, and they can reach out to specific communities. Let's say you have a kid with some pretty specific medical needs and you need somebody who's kind of connected to that medical community. They can reach out, they can do some research and reach out to that. Or if you have a kiddo that has to stay in a particular area, they can try to do some research and reach out to those communities. There have been times when we have put things in the paper, or there's also been there's a news channel that's posted some, they'll interview kids that are being considered, but those are not all of our kids. A lot of times those are kids that we are anticipating or currently having a hard time finding an adoptive home. Older kids, large sibling groups. You can imagine that not everybody is excited or thinks they want to adopt a sibling group of 6, right? That's a lot to take on. So sometimes, or if we have a sibling group with a really wide range of ages, like I've recruited in the past for kids, there were 2 kids that were 2 and 4, and then I had a 13 and 15-year-old, right? So if we were trying to look for a home together. So that's a very specific family that wants teens and babies. So we did, they were part of, I think it's called Wednesday's Child. And so there's a news anchor that we take them to an event and they interview them. And we can also make videos of the kids if they're old enough to participate in that, like take them to activities and kind of ask them what they want. Sometimes that helps families, they may read information about the kiddo and on paper that child sounds pretty intimidating, but when they see that child interacting with us or in their community on the video, that can personalize them and they're able to see past maybe a diagnosis to say, try to imagine what it's like to have that kid in their home.
Megan, do you do a like I'll say like a 2-step or a 3-step process where you might do a placement first with the end goal being adoption, but you want to do either a regular placement first or a guardianship first before it would go to full adoption?
Like most things in child welfare, I would say it depends. Generally, if we're recruiting for a home, we are generally placing for that purpose because they've been selected. So we're not going to finalize upon placement. Like it's still going to be considered a foster home, but they may be the designated adoptive parent or designated guardian. And then we would monitor that case until we would finalize. I mean, any kid who's in a home that ends up being their guardianship or adoption resource, technically, like they were placed there before. But generally, if we have recruited or have studied someone for a specific purpose, we're placing with that in mind. And then we kind of supervise it as long as we need to until everybody's ready to finalize.
Okay, thanks.
Yep. Any other questions about that? Okay. Sorry, when I'm looking at my presentation, I can't see you guys at all. So please shout out if I'm not trying to ignore you. Okay. All right. So once we have, yeah.
What's meant by genetic medical reports? Child summaries and
Yeah, that's what I was just about to talk about.
Right. Okay.
Yep.
Sorry.
Okay. No, okay. So the finalization paperwork. So paperwork that has to be completed in order to finalize the adoption. So child summaries and genetic medical reports on each kiddo. So what that is that's a document that my workers are writing. A child summary is essentially information about the child and why they came into care, what needs they have, what services they're going to need ongoing, and then information about any siblings that exist, relatives that we know of, and both parents' history. So it talks about things like the parents' educational background, any medical issues, what their experience growing up is, interests and talents, a bunch about the parents and the kids. So it's kind of a summary of this is kind of the family unit as we know it. And then the genetic medical is specifically family medical history. So if anyone's available in either family, we will ask them about any medical issues that run in their family. There's like a 3 pages list of things that, things we ask about: cancers, diabetes, high blood pressure, all kinds of things that we want to know, do they run in this family? Because that's going to be important for that kiddo to know as they get older, things to watch for their doctors to look for. And also has information about their birth. So like, were they exposed to anything in utero? What kind of, were they in the hospital at various times? So it's kind of a summary of any kind of medical information about that child. And so if you have one kid on a case, you'll see one of each of those for that child. And then obviously, if you have a bigger sibling group, there should still be one for each child that we are pursuing adoption for. And then birth and medical records. So we try to order any birth or any medical records that exist for that child. Sometimes those are hard to get if the child was not born in this country, or if they were born in another state and lived there for a while and nobody can remember where they went. We'll send out requests to doctors' offices and hospitals in the area that they were born or the parents said they lived, but sometimes we don't get responses, or sometimes the child didn't see the doctor. That was maybe part of the concern, is that they were having their medical needs neglected. So we'll access what we have, and it gets provided to the adoptive parent as part of a packet so that child has access to those records later. Adoption assistance, like guardianship assistance, we do that. We can do that anytime we have a designated placement and the child is legally free. And so that's essentially negotiating like how much that adoptive parent is going to receive on an ongoing basis. And it also does include, just like guardianship assistance, it includes the ability to ask for ongoing health care through the Oregon Health Plan or the local Medicaid if they're out of state. We offer mediation with the adoptive parents, bio parents, relatives, siblings, important people in that child's life. And then the last piece is once everything in the case is done and our central office signs off, they create what's called consent. So once we've terminated parental rights or that child's legally free, essentially we have the ability as the agency to consent to that child's adoption. So the vendor attorney is an attorney for the adoptive parents that they select through the adoption assistance process. So we send it to them, and they're the attorney that actually finalizes the adoption with their client, the adoptive parents. So anyway, that is what I have. Those are, yeah.
Another question. What about the child's immigration status? This is a kid who's got smuggled over the border when he was 2 years old, you know.
Yes.
And
So
according to some, he's not a legal citizen and ought to be deported.
Yes. So there's a couple ways we can do it. First, if that child is adopted by U.S. citizens, then sometimes finalizing the adoption can help speed up their immigration process. Or we might pause because we are in the process of trying to get this child citizenship through, we're paying for the immigration attorney and we're in the process. It kind of depends on what the family's comfortable with, what the immigration attorney's comfortable with, how far along we are in the process. So yes, we can finalize on children who weren't born here. Obviously, we work with the consulates of whatever country they were born in the beginning. So it's something that, we would move forward with, but it is possible.
Megan, in your finalization of paperwork, I didn't see or hear anything about a required psych eval or a current, recent psych eval.
On the kiddo?
Yeah.
So usually the psych eval is part of what that best interest finding that I was talking about. So the Oregon Court of Appeals has said that they need somebody with some very important letters after their name to say that this child needs permanency. And so we get those psych evals before that termination of parental rights if we think we're going to trial, to determine if this child needs permanency, and have an expert testify that at trial. We do not get psych evals on all children. That, if the parents relinquish and this child doesn't have any significant needs, we will not necessarily get a psych eval. If the adoptive parents or the team feel like this child needs a psychological evaluation, we're happy to get it for that child. But it's not necessarily an automatic. I mean, if you have a 2-year-old who doesn't have any special needs and we didn't need to go to trial, we would not have requested on that. If we have a 13-year-old with some pretty significant needs, probably that would be helpful, especially determining if that child's going to qualify for services, additional service to wrap around that adopted parent.
Okay, that helps. Thank you.
Yeah. Ideally, we would have gotten that well before finalization so that we could ensure that those services are in place before we finalize.
Okay, thank you.
Yeah.
Megan?
Yes.
Is there a post-placement probationary period before the adoption is finalized in Oregon?
Yep. We're required to supervise the placement for 6 months before we can recommend to finalize. We can do longer than that. That's the minimum. So, and that's, even if you have a child who's placed in another state, we still can't recommend to finalize until that 6 months. And we need that other state's permission to finalize. So some cases remain open much longer because there's turmoil or, the transition hasn't gone maybe as smoothly as we hoped. And so we'll keep it open to support the family and the youth in their placement until we finalize. And sometimes folks are ready at that 6 months and we recommend to finalize, and then it finalizes quickly after that. Kind of depends on the circumstance of that particular family.
Megan,
Thank
what
Yeah.
about a situation where a child's been adopted, couple months go by, things aren't going too well? Can the parents say, you know, I think I want to just bring him back to DHS and be done with this? Is that a possibility?
So they can't just drop them off at our doorstep and dissolve the adoption. But they can request what we call a voluntary placement agreement. So essentially, they would still be the parents. They would still work with us, but we could, if that child needed a higher level of care that they can't access in the community, we could work with them with the idea of a return home. Or if the adoptive parent chooses to abandon their child to us, we would be filing petitions on them, and they would potentially get a founded allegation and an open court case with them as the parent. But no, they can't just dissolve it. Does that answer your question, Evan? Okay.
Hey, this is Sue. And so my question along that line is, when you're writing up the information about these kiddos that goes out to these potential adoptive parents, do we get to look at that so we can see that you're presenting these kiddos in a very straightforward way? Because I know sometimes some of the foster families have said that they weren't given all accurate information before these kids came into their homes and stuff. So will we get to look and see what your information you're giving to these people?
So, well, first of all, I want to mention, like, the foster homes, a lot of times we don't necessarily have all the information when we first place kids in the home, but generally we haven't shared our bulletin. I don't know that, I mean, we wouldn't send it to you for approval. We could potentially show you what we send, but also the other thing is that that's not all the information they're going to get. So like, this is kind of just a snapshot. So they see this recruitment bulletin, they send us their home studies, we read through them and think potentially it's a good match. Then at that point, we would send them the child summaries or any kind of psychological evaluations or evaluations we have on the kids with some information about bio parents and resource parents redacted out of it. They would read it. Are they still interested? And then we would engage in a dialogue, usually an in-person or virtual meeting. And I've definitely had CASAs be part of those meetings where they're asking questions to the potential adoptive parent, and the adoptive parent is asking questions to the agency and CASA to get a better information about the kiddo. It's a balancing act with the bulletin. I'll be totally honest, right? You don't want to pretend this child is not who they are. But if you write out what this child is like at their worst day, you're not going to get responses, right? So it's like you want to try to be honest, but also positive. And so that is not the full picture of what that child's like. But in that follow-up information and further conversations, I think you get a fuller picture. And that all happens well before you would decide to take that family to an adoption committee.
Hey, Megan.
Yeah.
Your screen is still sharing. I think your email is popped up on the screen.
I'm so sorry. Thank you.
And you might have covered this earlier. I have maintenance at my apartment right now, so it's kind of loud on my end. But if there's multiple families who are saying they want to adopt a child, what does the process look like for the adoption committee selecting a family? Yep.
Can you see me now?
Yeah.
Okay, good. Sorry about that. Multiple screens. Technology is not my forte. Okay. So it depends. So if you have multiple recruited for families, we could either, depending on the age of the child or needs of the child, do a caseworker selection or go to a local adoption committee. So that means here in Marion, but with Marion folks generally. If you have multiple relatives or a relative and the current provider, you would go to our central office adoption committee. So that has folks around the state, and it's a virtual committee who have experience in adoptions who would be part of that committee. And in either the local or the central office committee, you would have someone called the adoption decision specialist. That's somebody who's been approved by the agency to make final decisions on adoptions based on experience and stuff. You would have a facilitator, and then you would have 2 committee members, and then anyone from the child's team. So caseworker, CASA, child's attorney would be invited. We would have the adoption workers representing whatever families were present, were being presented. And then for just the child's portion, we could bring in folks that we thought had valuable information about the kiddo. Sometimes we'll see child's therapist, the resource parent, anyone else who we think has really good information about that kid that we think the committee needs to know in order to make a good decision for that child.
Do the children ever have an opportunity to be present at some of these meetings and committees?
They are present for our PERM committees. They're not present for our adoption committees. And here's why. Because we do not tell the children, we ask them what they want in a family. And especially if they're living with folks or they know folks, especially with relatives, like they'll tell us and we will share their opinion with the committee. But sometimes we have to make decisions based on more information than we can share with the child, and so they are not present for the adoption committees themselves. Either are any of the families who are being considered. They cannot show up as well. But we collect that information ahead of time. So a child is welcome to write a letter or share their opinion with their worker, CASA, whoever, of what they want. But if we're recruiting for families, we do not introduce any of those families to the child until we've selected somebody. And that's because, somebody might back out, somebody might not be chosen. It can be really confusing for a kid to have all these families coming forward and still making a decision about whether they want them. So we do not introduce kids to families unless they are selected, if it's a recruited family.
Hi, this is Paul Lindsay.
Hi.
Could you also explain to us, once the judge approves the adoption, about the appeals that can happen?
You're talking about an appeal of a termination of parental rights, like the one you're waiting on right now. Yes. So if the parent's rights are terminated in a trial, or actually in a trial without parent, the parent has the ability to appeal that decision to the Oregon Court of Appeals. That can be a very long process. That actually can happen at any hearing where a decision is made. We have families who appeal their jurisdiction, their permanency decision. It happens on permanent guardianships. So, you have a judgment finalizing that perm guardianship. We have some of those under appeal. So they have a legal right to appeal that decision. The appeals court is not on ASFA timelines. They take as much time as they want. So generally, I would say it takes us about 8 to 12 months to get a decision back from the appeals court, whether they're upholding the decision made by their previous court, the juvenile court, or they're overturning it. So like I said, it can be jurisdiction, it can be a permanency judgment, it can be a termination of parental rights, it can be finalization of a perm guardianship, and we wait. So if the appeals court upholds our decision, technically the parent could appeal it to the Supreme Court, though I don't know if the Supreme Court has ever taken on any of our cases, and it's the Oregon Supreme Court, not the federal Supreme Court. But so I don't think they've accepted any, but they have the ability to do that as well. But once that's their ability to appeal is over, then we can move forward. If you have an adoption on an appeal, you are waiting. So because, essentially we can't finalize the adoption until we get notice that they've upheld that appeal. Also, if we are moving forward with a termination case and our jurisdictional bases or our our permanency decision is overturned by the appeals court, that can mess things up too, right? Because if the judge said, yes, I'm changing the plan to adoption or guardianship, the parent appeals that, and the appeals court overturns it, it kind of makes our termination null and void. So that's something to be aware of if there are appeals happening in your cases. And we are at the mercy of their timelines. Like, they make oral arguments. Sometimes they present motions. We're not parties to that appeals court. I mean, there is an attorney, but we don't attend those. So yes, did that answer your question, Paul? Okay.
And Megan,
Yes.
where is the child during this process of appeals then?
They are in their adoptive home waiting.
Hmm.
Yeah. So that can definitely extend the amount of time that a child's in that adoptive placement before finalization.
And Megan, quick question, I should
Yeah.
know that. What's the statute of limitations if a parent has their rights terminated?
They have 30 days. 30 days to make an appeal on any decision at after the time that the judgment is signed. So that's true for all of those those abilities to appeal, like I said. So after the jurisdictional order is signed, the permanency order is signed, the termination of parental rights order is signed, the parent has 30 days to file an appeal.
Okay, thank you.
Mm-hmm.
Bacon,
Yes.
horrible question. Suppose you have
Horrible question is how you said.
Yeah,
Okay.
prospective adoptive parents who say, I only want to adopt a white kid or something like that, you know, or
Yeah.
I'm Chinese and I only want a Chinese kid. How does DHS respond to that?
Well, if we get a home study and somebody says they only want to adopt children who don't match children that we're recruiting for, it happens not only just in specific racial groups, but more commonly age groups or description of needs. We likely would not consider that home. We would, read the home study and be like, oh, that's not a good match. If we think otherwise it's a good match, we might reach out to the adoptive parent, the adoption worker, and say, hey, the home study says they were not interested in kids like this, and our kids are like that. Can you clarify if there was a change in their thought process or why they decided to submit? Depending on what the answer is, I haven't had it come up where they said I would only adopt this racial group, and we've asked that question. It comes up, like I said, more often if like they originally said they only wanted to adopt kids under the age of 5, and my kid I'm recruiting for is 7, or things like that. But we can ask the adoption worker, hey, these don't match. Help me make this make sense. And then based on their answer, we can choose to consider them or not consider them. But there's nothing that obligates us to consider a home just because they submitted their home study to us. Like, we can read it and be like, this is a horrible match. This would not be good for our kid, and just put it to the side. And normally I write a big no on it because it's not a good fit for the kid, because some kids need very specific things. They need a parent who has specific skills or they can't be with younger kids or older kids or whatever, right? And so if you don't think it's a good match, we're not going to move forward. We're not going to move forward with that family. We're going to put them to the side and read the next home study.
Thank you.
Yeah.
So Megan?
Yes.
What is the success rate of your adoption in the state of Oregon?
I don't know. You're talking about like non-adoptions that do not disrupt. Is that what you're asking about?
Well, yeah, when a child is adopted, sometimes, it doesn't work out.
Yeah.
And that's what I'm referring to.
I don't know. I don't study that piece afterwards. I have heard that it's more our adoptions have a better success rate of sustainability than our guardianships, but I don't know the numbers. I think somebody at our central office probably looks at those, but I often honestly do not know that adoptions or guardianships disrupt, because they may not be placed or happen in this county. You know what I mean? Like, so I don't know.
Okay.
Yeah.
I'm just curious.
Yeah. I will say, I didn't mention this in the guardianship portion, but we can recruit for a guardian as well. Our success rate in Oregon is not great, but it is an option. And usually what will happen is it won't move to a worker in my unit, but my worker will assist in the in the recruitment piece, because my workers do all the recruitment in the branch, but it'll stay with the regular primary worker. So that is an option. It hasn't been very successful, but it is an option.
Yeah.
Oh, following up on that,
Yeah.
for guardianship, once the court approves that the child can now be in a guardianship, but until there is a guardianship, the child is still just treated like a regular foster child wherever he's placed at, or she.
You're talking about if the plan gets changed to guardianship, but we do not have an intended guardian. Is that what you're talking about?
Yes.
Yeah, essentially it changes what our reasonable efforts are supposed to be going to. So instead of our reasonable efforts supposed to be concentrated on reunification with a parent, it means our efforts as an agency are supposed to be centered around locating a guardian. So that would be some like calling relatives again, doing recruitment, doing that child specific recruitment, whatever that looked like. So in terms of like their everyday life, yes, it would be nothing honestly would change for them. They would still remain in care at the level of care that they're supposed to have needed until we can locate a guardian.
Then do you consider, if that drags out for like a couple of years, nothing happening, on changing the plan then to adoption? Since adoptions tend to be more successful, or how does that decision work?
We certainly can. We can certainly staff it to determine, let's say we try a guardianship. Like we have one right now that we're recruiting for, or we're going to start recruiting for a guardian. And if it's not successful, they're going to come back and staff it at that LES staffing to determine if we want to look at adoption, to see if we can find an adoptive parent if guardianship recruitment's not successful. So that does happen.
All right, thank you.
Mm-hmm. I mean, we could do that for any plan, right? Let's say we decide not adoption, but that child has now old enough that we could look at APLA. We could also look at that. It really depends on the specific case and kiddo.
And if the child is 14 or older, do they have a say in this adoption process?
Yeah, so any child 14 or older has to consent to their own adoption and or guardianship. So they certainly have a say in what they want. Sometimes kids have no idea. So it takes some like talking, maybe working with a therapist to determine like, I mean, adoption and guardianships and different kinds of guardianships can be complicated legal questions for adults. So certainly we try to get them some support around those things. But yes, they have the ability to say no or yes, and they have to legally sign off at 14. But obviously a 12-year-old, if we say, oh, you're going to be adopted, and they're like, absolutely not, they could make that adoption fail. You know what I mean? If they didn't consent to it. So we try to take, any child who's able to articulate what they want, we're trying to involve them to their developmental level in the case planning, or we should be.
Very good. Thank you.
Any other questions before we wrap up? Check the chat here. Don't see any in the chat.
Megan, before we sign off, I appreciate what you do. Thank you.
You're welcome.
Yeah, thank you very much. If you don't
Thank-
mind, Megan, could you send me the slides that you used?
Yeah, I'd be happy to.
That'd be great. Thank you very much.
Thank
Yeah.
you, Megan. And Dennis, I was going to say that too. This is Sue. I'd appreciate getting copies of those slides.
Yeah.
Yep.
Yeah, I'll send them out to you. Megan,
I will
email
send them to you right now, Dennis.
Perfect. Thank you very much. And I will go
Yeah.
ahead and send it out to everybody.
Thanks, Megan.
Bye,
Awesome.
guys.
All right.
Appreciate
Thank you
it.
guys very much. Megan, I really appreciate it. This was
No
great.
problem. Anytime.
Appreciate it. All right.
Bye.
Bye.
Y'all have a good day.
Bye.
You too.